Welcome back to the Making International in Korea video series. In this video, I'll be explaining on very specific case on direct application of treaties based on Constitutional Court's decision issued November 26, 1998. This is about the fact is the person to the signing of the WTO agreement creates the tariff rate change, thereby increasing the criminal sentence of the accused. The defense asserted that the penalty increase based on the treaty and not a domestic registration which violates the principle of legality of the Constitution. The Constitutional Court held that even if a criminal sentence were to be increased by a treaty, this still had the same effect as an increase caused by the domestic registration. It was an example of recognition of direct application of treaties. The claimant alleged that in order to increase the punishment of tariff violation, there must be an amendment of tariff law or the act of the aggravated punishments of the specific crimes. Thus, he argued that the increasing the punishment for tariff violation solely based on a treaty is a grave violation of fundamental rights and also runs counter to the principle of legality. The Constitution states in a latter sentence of Article 12.1, no person may be punished or placed under preventive restrictions or subjected to involuntary labor except as provided by the law and through lawful procedures, thereby regulating criminal punishment through law and due process. While Article 31 provides, no citizen may be prosecuted for an act which does not constitute a crime under the law in force at the time it was committed, thereby prohibiting criminal punishment of an act not constituting a crime at the time of commission. And also Article 6 states the treaties duly concluded and promulgated under the Constitution and generally recognized rule of international law have the same effect as the domestic law of the Republic of Korea, providing that treaties duly concluded and promulgated have the same effect as domestic laws. The Marrakesh Agreement was duly concluded and promulgated, thereby having the same effect as domestic laws. Thus, even if crimes were to be created or punishment increased by this agreement, it would be as if done so by the domestic laws. In other words, even if the punishment for the tariff violation were to be increased by the Marrakesh Agreement, it cannot be said that it was an awful criminal punishment or the punishment for an act that did not constitute a crime at the time of commission. Therefore, we cannot conclude that the old act of aggravated punishments of the specific crime, Article 621, or an act on the marketing and price stabilization of agriculture and fisheries products, Article 10.3, either violates the principle of legality or the fundamental human rights and personal liberty of the claimant. Let me touch upon the other issues based on the actual case. The self-exacting treaties, which is based on Supreme Court judgments in 1999. The fact of the case is like that. The plaintiff, while heading into Kumho Company Trade Union, was pronounced guilty for violating the Article 13.2 of the Labor Dispute Adjustment Act, prohibiting third-party intervention. After the conviction was affirmed by the Supreme Court, he became the first Korean to report this case to the Human Rights Committee, established under the optional protocol to the International Convention on Civil Political Rights. This Human Rights Committee found that the punishment of these claimants, Song Jong-gyu, violates the right of freedom of expression as provided in the Cabinet. The Human Rights Committee, while stating that Song Jong-gyu was entitled to an effective remedy, including appropriate compensation, further invited the Korean government to review the Article 13.2 of the Labor Dispute Adjustment Act. When the government did not carry out the decision of the Human Rights Committee, Mr. Son Jong-gyu brought a suit against the government for damage, point out to Article 2.3 of this International Covenant on Civil Political Rights. Article 2.3 of the above International Covenant provide for the obligation of states under international law to secure the legal system that would ensure effective remedy for persons whose rights or freedoms as recognized in the covenants are violated. Remedies such as compensation suits against the state can be claimed based on domestic law, for example, State Compensation Act. Therefore, the above provision does not individually create a special right for a person to claim remedies, for example, compensation against a member state of the convention. Let's move to a different topic of the effect of treaties as domestic law. This is based on the Constitutional Court's decision in 2001 affirming the unconstitutionality of the ratification of the fisheries agreements between Korea and Japan. Article 6.1 of the Constitution states, the treaty is duly concluded and promulgated under the Constitution, and the general recognized rule of international law have the same effect as the domestic law of Korea. The agreement above is a treaty duly concluded and promulgated under this Constitution regarding the fisheries between our country and Japan, and therefore has the same effect as domestic laws. Thus, as observed above, the constitutional appeal can be made regarding a law in exceptional circumstances of when a fundamental right is infringed by ordinance that is not separately executed. Let me touch upon the other case, which is the Constitutional Court case decided in 2003. This is about affirming the unconstitutionality of a medical treatment law. The claimant alleged that the provision regarding preliminary examination breaches the Regional Convention on the Recognition of Studies, Diplomas, and Degrees in Higher Education in Asia-Pacific, thereby failing to recognize the education obtained abroad and thus additionally limiting the achievement of the domestic licenses. Our country is a signatory of this convention, and though it has a legal effect, its status is not constitutional and therefore cannot be criterion for the evaluation of validity of the preliminary examination provision. The other case which I want to move on is again Constitutional Court case, which decided in 2001. It's about constitutional appeal regarding articles of agreements of the International Monetary Fund. Let's move to the Constitutional Court case decided in year 2001. This case is about constitutional appeal regarding the articles of agreements of the International Monetary Fund. Article 680 of the Constitutional Court law provides that the object of trial shall be law which should be read as including treaties. This court has early made a judgment on the context of a treaty on the ground that a treaty having the same effect as domestic law can be subject to evaluation of its constitutional validity. The article in this case was concluded and ratified by the National Assembly and therefore has the effect of domestic law. pursuant to Article 6 of the Constitution, which would be equivalent to the effect of registration. Because this particular article regards the immunity from jurisdiction, its nature of direct application would make it subject to evaluation of constitutional validity.